Got it. All right. Good evening. Good evening to everyone. On behalf of Abba Sansum, we want to welcome you to our offering this evening. This conversation is super, super close to my heart. It's one of those that, as much as it's something that a lot of us put off on the back burner because it may seem a bit cumbersome, but it's stuff that is so vital and so important. And I've experienced it even in my own life, the benefits and the consequences of not having planned. And I'll share a little bit more of that later. So I am especially excited that Abba Sansum has brought us together for this purpose tonight. And the topic that we are covering tonight is estate planning. And I know many of us may say estate planning is something that people with wealth, that's for wealthy people. That's for people with a lot of money. And I am confident that our professional this evening is going to dissuade you of those false beliefs because it's something that's super important for all of us. And she'll definitely share with you just a bit as to why you, even you, wherever you are, millennial, starting off working, even if you have worked your entire life and you're getting towards the end of your work years, Sandy's going to share with you really why it's important for all of us to focus on estate planning. So I want to tell you a little bit about our guest, and I'm super excited that she was available to join us this evening for this talk because it's great to have an expert in the family. And there's nothing like having people that really genuinely care about us and really genuinely care about our community to share their time and their professionalism with us. So with that, Sandy Bouawon, I like making sure that we pronounce that right, is a Haitian American who was born in Boston, Massachusetts, and raised right here in Miami, Florida. Sandy is the aunt of an autistic 15-year-old teenager, and she serves as an advocate for families who have children with special needs and require long-term care planning. Sandy also is the co-founder of Spectrum Law Firm in Miami, and her primary practice areas include probate, guardianship, wills, trust, and estate planning, which are all the topics that we have that she has graciously agreed to talk to us about this evening. Prior to the practice of law, Sandy served the Broward County Public Schools for about 8 years as a middle school science teacher and an elementary school pool and interim substitute teacher. At the start of her career, Ms. Bouawon served as a nonprofit community liaison and program coordinator in Fort Lauderdale, supporting the needs of the Haitian and Caribbean communities for over 4 years. Ms. Bouawon's background is community outreach, public education, and legal services, and allows her to provide essential information in the community and promote legal education. Sandy, your bio reads like someone who I know that I can trust on this topic. It says to me that you have a heart for the community. What brought you to law, if you don't mind? Let's start with a little bit of that.
So I started off my career working in the nonprofit realm, as many of you are currently working in that realm. And I spent a lot of time at the courthouse, many times seeing our lovely Haitians with their attorneys who don't speak their language. And so because I was in a position working for a nonprofit providing certain types of services, I got to interact with a lot of attorneys all the time. And it was something that kind of stirred up from there. But it took years before I actually went forward into practice. But that was like the early starts. It's just seeing a need and realizing it was something that I could do.
I love that. I love that. I love that you started your career in education, and it seems that we've had you on once or twice before, that there's still this passion for teaching and for making sure that our community has the information that they need. When it comes to estate planning, what is estate planning? Let's start there. Educate us on that. What is estate planning?
So estate planning is the process where you basically take some important information and organize it into certain documents, as well as making plans for things that are obviously going to happen in our lives. Like, we could potentially get sick. We are going to pass away at some point in time. So you need to put some things in place to make sure that your wishes are put into action if you become ill and can't handle your affairs on your own, as well as your wishes are met at the time that you pass away. So estate planning allows you to organize all of your affairs and prepare for each aspect of your estate, because your estate is everything that you own in your name, but it also involves all of the decisions that need to be made on your behalf, whether it be medical decisions or financial decisions or decisions after your death.
Elaborate a little bit for me on what is. Break down for the people. And I think our connection might have been a little bit wonky if we missed anything, but elaborate for me, what is an estate? Because the word itself to the common ear may seem a bit lofty. What is an estate in this sense?
Yeah, I think the definition of an estate is what kind of throws people off, because it's not something that we usually talk about in our everyday conversation, right? So an estate is everything that you own basically in your name and everything that you have an interest in. So when I think of an estate, I can think about the home that I own, money that I have in the bank, my financial accounts, any investments that I have, my business, anything that is a part of me and anything that I have control over. So the way that your estate works is, because things are titled in your name only, there are documents that would need to be in place in order for you to have someone else step in on your behalf. And also, after you pass away, there are documents that need to be in place to make sure that what you want is what happens with your estate. So think of your estate as a container of every single thing that you own, and it is all in your name. And in order for someone to get access to those things, they would have to have some pieces of paper in essence, if that makes sense.
It does. It does. It makes a lot of sense. So by that definition, I do not have to be a wealthy person in order to be considered as someone with an estate.
Right, absolutely. You don't have to be a wealthy person to have an estate, because your estate has to do with everything that you own. It's not about how high of a value what you own has. So it's just a matter of making sure that you cover all of your bases regarding what you have. So let me give some examples to help clarify. If I own a house and my house is in my name only, I'm the only one that can make changes to the title of my home, right? I'm the only one that can transfer my property to someone else. I'm the only one that can deal with the mortgage company. I'm the only one that can deal with my city and handle whatever the affairs are of my house. If something happens to me and I get sick, let's say I get into a coma and there's nothing I can do, right? I need someone else to make decisions for me. Well, if I own a house, unless someone else is listed on the deed, we're kind of out of luck there. We need someone else to have the authority to act on behalf of the house. So you need to make sure that you have something like a power of attorney, which is a document that allows someone else who you give the authority to make decisions on your behalf financially. That includes things like, your accounts, anything dealing with your property, investments, lawsuits, all of that. But with a piece of property, you know that a piece of property has someone's name attached to it, and technically only that person can make decisions about it. But when you're doing estate planning, you're saying to yourself, what happens if? What happens if I get into an accident and I'm in the hospital and I can't pay the mortgage? I can't communicate with the mortgage company. I can't handle the day-to-day activities like mowing the lawn and paying the lawn guy, handling the pool, or whatever it is that has to be done daily. So I have to have somebody who has the authority to make those decisions on my behalf, right? Somebody that I authorize. So I'll give you, oftentimes older parents will have their children as their power of attorney. Children will have their parents as their power of attorney, because you want to have somebody that you trust, because a power of attorney can be a document that touches everything that you own, or it could be limited to, let's say, your piece of property or a specific bank account. But Your estate
Okay.
is everything
So
that you own, and therefore you have to have certain things at play so that you can be able to do what you need to do with your property in your absence.
understood. So I couldn't just give someone the password to the PIN number to my card, and if something happens to me, they can just pull the money out. Let's say I pass away. Let's say
Right.
I pass away and I have money in my account, and I gave my sister the PIN number and said, hey, there's money in this account. Does she have the authority now that I'm gone to just pull the money out?
Technically speaking, when you pass away, you are no longer. So no one really should be accessing anything that you own unless they have authority. So if you had access to the account, maybe you're listed on the account, that's one thing. If you're accessing the account just because you have a card and you have access to the PIN, a little tricky, because it's going to be a question of, well, are there other siblings that are entitled to those monies? Are you the only one? You know, you get into a little bit of a touchy area. So my rule of thumb is when someone passes away, understand that you technically aren't authorized to touch anything that they have unless you were listed on that account or unless you were a joint owner.
So what you're saying is, regardless of my relationship with said individual, my sister, my son, I had a close relationship, they loved me, they absolutely would want me to have the house, to have the car, to have the cash that's in the account. They absolutely would want me to have it. But they never got around to issuing any paperwork that says that I have access to this. But they told everyone. Everyone
they
knew.
told everyone, but they needed to take some actions to make sure that you have access to those monies. So banks, for example, have what's called payable on death or terminable on death. And what that is a beneficiary designation on a bank account that says, when I pass away, this is who I want my money to go to. So that's the better avenue to deal with is if you have a bank account or any financial account, you know, life insurance, a retirement fund, you know, those cryptocurrency that everybody's investing in, any financial accounts that you have, your goal is to make sure that you have some kind of beneficiary designation listed. So in that instance, it doesn't matter whether you have any other documents in place. You already have something under the law that allows you to receive. If you don't have beneficiary designations, the next option would be to make sure that you have a will in place so that when you pass away, those monies, you're going to have to go through the probate court process, but those monies ultimately will be distributed to you after a court defense and things like that. If the person's still living, you can have a power of attorney. So that way the power of attorney could have the authority to do whatever they need to do in the account for your support. Or if that person says, hey, I want you to have what's in the account, then you have a document that gives you the authority to access the account. But technically, when someone passes away, they are no longer. And unless you are listed with authority on the account, like you're a joint owner, or you're listed as a beneficiary, those funds shouldn't be touched. And the reason I say it, I've had too many instances where one sibling, because they had access, emptied the account. And then the other siblings are like, well, mom said that I was supposed to have 5,000 and so-and-so was supposed to have 1,000. And that sibling's like, well, I'm the one that had the card. I was the one taking care of mom. And mom told me I could have it. So you get where you could have some conflict and problems. If you're just one person, you know, it's possible that you might be able to do some different things. But if you have multiple siblings, it's a real danger zone when you decide to take those matters into your own hands.
So make the plans and the decisions on the front end.
Yes.
There are a few words that you use that I would love if you broke down for us just a little bit more. So you've explained that we have to leave some sort of document, some sort of information that actually says what should happen when we are unable. So we'll talk about when someone has passed away, and then we'll talk about if you so happen to live, but you're unable to actually make those choices for yourself. Right. When someone has passed away, what are the mechanisms by which they could have made those choices, have made those preferences known?
So when someone passes away, the things that we look for, my first question is always, did they have a will? Because if they had a will, which is often called a last will and testament, the will is going to say, these, I own this, I own that, these were my children, this is how I want what I own to be spread amongst my children or my family or the charity, right? I can make a decision regarding who I want to have what I own. Now, there's a difference in having personal items and having items that are going to require some kind of court order. If it's a bank account and there's no beneficiary designation, you're going to have to take that will through the court process. If it's a financial account, an investment, a 401k, and there was no beneficiary listed, you have to go through the court process, probate. If it's a piece of property, investment, rental, homestead, again, you got to go through the probate court process unless you have other things in place, right? Your will is only instructions to the court. It does not transfer anything. I've had a number of situations where someone thinks, well, mom left me in charge, my name's in the will, I can do whatever. No, it depends on what your mom left when she passed away or what your dad left when he passed away. If they left things like real property, real estate, and they did not leave any other document in place to transfer that property at the time that they passed away, you're going to have to take that will to the court and go through the probate court process. You will get an order from the court that says, we have a will, the will directed that the property is going to go to this person, and this order directs that the property be transferred to that person, right? Then you're going to record that document. There's some steps to that, but you have to get a court order that's going to be recorded on the public records that allows the property to be transferred, and it'll be transferred to whoever it goes to. And then we can talk about homestead and things like that. If you're in Florida, we have homestead protection on, certain types of property that was your residential homestead when you passed away, versus if I have investment property or properties that I'm using for, other purposes. Okay. So if I have a will, I have a document that gives my family and the court the necessary instructions to say, I had this. So when I pass away, I want this to go to these people. If you don't have a will, what happens in Florida and many states across the US is you're going to go through a process that's called intestate succession, which means what happens with what you owned at the time that you pass away is transferred under state law. And so under state law, it'll say, if you were, if you passed away and you had a spouse, your spouse is entitled to a certain amount of your estate. If you had children with your spouse, there's an entitlement there, right? If you had children outside of that marriage, your children, as well as your current spouse, when you pass away, will have some entitlements there. So the law already has in place what happens to your belongings when you pass away. And it provides for how the monies and property are going to be divided. It also provides information on when and how creditors are going to be paid, and whether or not there's some other monies that can be reimbursed, because many folks don't know, when you're going through the probate court process, depending on the type of process you go through, you may be able to get reimbursed from the estate before other people, before the other heirs get their monies, before creditors get paid. You may be able to get reimbursed for things like funeral expenses, any expenses to maintain real estate, expenses just, to hire an attorney and to do the things that need to be done to finalize the estate. So just to kind of summarize, when you have a person who passes away, if they had a will, there is a process, and the will only gives instructions. It does not transfer property. So you got to go through probate. If you don't have a will, again, the statutes, the Florida statutes are going to give instructions, and those instructions will now be followed by the court since we don't have a will to look to. Under the Florida statutes, we're dealing with more even Steven type things, right? More things are going to be distributed in an even way, especially if you have a surviving spouse and you have kids. Whereas in your will, you can give instructions and say, I want my belongings to be divided this way. I want one child to get everything and this child to get nothing. So you can do those types of things to create your own will. I I'm going to answer a question that I'm seeing. I don't know if you want me to touch on questions or you want me to just focus on our
You froze
topics
for a quick
first.
second. I didn't hear.
Did you want me to
You
touch
froze
on any
for a quick second. I didn't hear
questions?
it.
Did you want me to touch on any questions that I'm seeing pop up?
Yes, you can. You're watching too? Yes. Yes, you can.
So, so I see a question about
If it's too far ahead, if it's too far ahead, because we're going to talk about what if you live.
Gotcha.
And I also am going to ask you to touch on trust after this, but go ahead.
Okay, so I'm seeing some questions about, you know, drafting a will and creating the document. You need a lawyer. So here's the thing with estate planning.
Go ahead. I'm in the comments now. Feel free.
Okay. Here's the issue with drafting documents. If you don't know what you're doing and you don't know the law, it's a little bit difficult for you to draft certain types of documents. And I would include that to be a will, a power of attorney, a healthcare document, anything in the estate planning realm. If you don't know the information, you're not an attorney, you don't have a legal background, it's a bit difficult for you to understand what needs to be in, what the requirements are to execute that document and get it signed and notarized, and what will happen when that document has to face the court. Or better yet, what happens if somebody contests the will. So it's important for you to know that even if you choose to draft your own document, which you can very well do, it's important that you sit down with a professional to review that document to make sure that you're satisfying the requirements to have an effective will in Florida, that you're satisfying the requirements to execute the will, you know, to get it signed in the presence of witnesses and a notary, that you're satisfying the requirements to cover all of the different areas that you need to cover to make sure your will doesn't have gaps. Because the moment that your will doesn't cover something, guess what kicks in? Florida statutes. And I can't tell you how many times I've had a fill in the blank will. I've had a will that you can clearly see somebody did on their own. And because they were missing something, we still had to go through an extra court process instead of following the instructions in the will. Because some of the wills, we're only transferring personal things. We're not doing anything like real estate or bank accounts. But because people make errors, it could be there's artwork and there's other things that might have value. And because the will didn't cover those things, now we're in a court process. Also, many times people will fill in the blanks of a will, and because they don't have enough space on the lines, you know, they skip around like they're filling in an application. Well, guess what you're doing? If you leave out one of your children or you leave out a name somewhere, that name is not there. So now the court has to figure out what your intention was when you created the will. And if the witnesses and the notary are all in agreement that you signed it, that's what your intention was, that's what you wanted, you're out of luck if you were the one left out of that will, right? There's another question about what is the difference between estate planning and a will. So estate planning is a whole process, and it involves preparing documents like a will, a trust, a power of attorney, healthcare documents. It also involves answering important questions that will lead you to preparing certain steps, like preparing deeds while you're living, like beneficiary designations, like doing certain types of tax strategies, or having specialized trusts or special needs long-term care planning, or elderly needs and long-term care planning for elderly family members. So estate planning is a whole process for which a will is included in that process or in that conversation. Whereas a will is actually a document that allows you to make decisions about your last wishes. That's why they call it a last will and testament. It's a document that gives instructions to your family and to the court, okay? And then the question was, does a will differ from an advance directive? So when I'm talking about a will, I'm not talking about a living will. And many times people come to me, they're like, well, I need a living will. A living will and a last will and testament, or what's regularly called a will, are two different documents. A living will talks about healthcare decisions. And it's like the do not resuscitate information. You know, I don't want to be kept on a machine if I'm unable to survive on my own. So that's what a living will does. It gives you some instructions in end of life decisions. An advance directive is basically that. You're making decisions in advance for the event that you may become ill, or you may have some kind of circumstances where somebody has to step in to make medical decisions on your behalf. So all of these are estate planning documents. They're not wills, but they are all estate planning documents and they have different purposes. I'm going to try to check off the
Thank you
ones that
so
I've
much.
answered.
Thank you so much. I think you hit all of them thus far, and we are going to circle back around if we have any additional ones. I have it in my palm now, so we're going to circle back around if we have any additional ones. I want to go back just briefly and just give you the opportunity to reiterate for our viewers, because part of our entrepreneurial spirit is that I've seen that done, I can do that. And something like this, and especially for those that may own things of value, a property, you own a home, like you said, you may own art, you may own something that is going to be of financial value to your heirs, those that are left behind, that are left after you pass away. Something like this is one of those times where, although we are very entrepreneurial minded, it may be worthwhile to speak to a professional. On average, and you don't have to be exact, but one of the reasons that we often choose to go our own entrepreneurial way, as opposed to soliciting the help of a professional, is that, oh, this is going to be so expensive. I can't afford an estate plan.
Right.
What dictates the cost? And you can be general. What dictates the cost of an estate plan?
So I love this question because I always ask myself, how do people know it's going to be expensive before even sitting down with someone to find out? You know, I've always wondered that. So here's the thing with estate planning, and this is where the comparison begins. With estate planning, you're going to sit down with someone and have a consultation. Some attorneys charge for a consultation, some don't. Some attorneys charge flat fees, some of them charge hourly fees. Your work depends on your circumstances, right? So an individual who is single, has no children, owns no real estate, only has accounts, their planning is going to be one set of situations. An individual who has children, who is married, who maybe has real estate and other investments, has another situation. An individual who may only have, cryptocurrency or, something in that realm has their own circumstances. So it all depends on the circumstances. You could spend hundreds to thousands on planning, but if you allow yourself to have to go through the court process, you will, those keywords, will spend thousands. So if I do it in the planning phase, I could spend hundreds because I have time to phase things out. You know, I can work with my attorney over time and say, okay, what do I really need right now? And what do I need to plan for later, right? I can work out my plan, because estate planning is not, I create the document today and it sits and then it waits until I pass away. Estate planning is an ongoing, updating, making changes according to your life, because the plan is based upon your life circumstances and what you own at the time and what your intentions are. So as your family changes, your plan changes. As your assets change, your plan changes. Whereas when we wait to go,
so you don't sit and forget it.
You don't sit and forget it, because
so
if
you don't
do that,
forget it.
No, you cannot do that, because laws change, your circumstances change, you may change tax bracket. I mean, like, there's so many different things that can change that you need to make sure that you keep up your planning information. As far as things like probate and guardianship, you will spend thousands. And when you start to tack on the bill at the end of a probate, you could be in the 10, 15, 20, 30, $40,000 before we even hit ground, right? Before we even start getting to things like creditors and things like, breaking down expenses amongst whoever the beneficiaries or heirs are. So you can save yourself thousands by just taking the time to strategize and say, you know what, I need to get my affairs in order. Let me start somewhere. If you want to prepare documents on your own, sure, do that. If that's what you want to do. But sit down with a professional and say, hey, these are the documents that I prepared. How much would you charge me to review my documents and give me some guidance on this, right? Many attorneys are going to tell you, I'm not going to give you legal advice, but I'm going to tell you what your document says. And I'm going to tell you where you have some gaps so you can understand, this is not an easy task. Like, we don't just put papers together and then we're done, because as the attorney, I'm liable for what your documents say. So if I make an error, it comes back to me, right? If you make an error, it doesn't come back to you because you will be passed away. And that error is going to affect your family, who's now going to spend thousands of dollars to fix that error.
In order to fix that.
Yes.
So you mentioned guardianship in the same breath as probate. Can you delve a little bit more into under what circumstances does a guardianship take shape?
So I want you to visualize. So if you put your documents in order, if you have your estate planning in place, that's the normal, right? That's my middle ground. That's where I should be. So everybody should have a will, a power of attorney, a healthcare document. If you need deeds done for your property, you should have that. If a trust is necessary for your circumstances, that's something you should have. Prenups and postnups and those types of things. Those are things that you have in place. That's the norm that we should be aiming for. When you don't have your estate planning in place and you pass away, we are going down the probate process. If you have at least a will, sometimes you're still going into the probate process because there may be things that need to be done that weren't taken care of while you were living. If while you are living, you have your documents in place, but they weren't done properly, and I've had that situation very recently where someone did their power of attorney and the power of attorney wasn't worth the paper that it was written on. So when they went to court, they opened a full-out guardianship. So guardianship is what happens when you have medical needs and financial needs that you can't satisfy anymore because of a medical condition, because of something, maybe an accident, or something else that happened to you. Or it could be just your old age or something in that realm where it's like Alzheimer's, dementia, things like that. So what happens with guardianship is the court has to appoint someone to serve as your representative because you don't have papers in place to give instructions and to identify who you trust to handle your medical and financial decisions. So what happens is you have to go through the court process. They have to make a determination of whether or not you have capacity, whether or not you're capable of making medical and financial decisions for yourself. And you can have a guardianship over just your person, which basically is like your medical decisions, your activities of daily living, or you can have a guardianship over your property, which is everything that you own. If it's property, real estate, bank accounts, other financial accounts. So you can have a guardianship of either one, where you have a person for each of those roles, or you can have what's called a plenary guardianship of the person and property, which means someone is in charge of everything that you own as well as your person. And the typical reason that a guardianship comes into play, you have an adult child who has special needs, who can't make decisions for themselves and needs long-term care and has to have someone make decisions for them. That's a guardianship situation. You have situations where an elderly adult or somebody who's just getting up there in age and they develop conditions like dementia, Alzheimer's, you name it, there's a whole long list of conditions. That's a guardianship circumstance. Any children that receive an inheritance or a settlement from a lawsuit, sometimes a guardianship is needed because they're under age 18. And what happens is, please understand that money that a child receives under age 18, once it covers over a certain amount, it has to go into the guardianship court because those monies are intended for the kid. And when they turn 18, that's when they'll be able to get access to those funds. So you have guardianship for minors, you have guardianship for special needs circumstances, and you have guardianship due to medical conditions or accidents and things of that sort. So if you prepare all of your necessary documents and they're done properly and executed properly, you can avoid the guardianship court process, which, much like probate, is going to be thousands of dollars. And if you mess around and you don't have anybody who can satisfy that role as the guardian, because you have to have no fraud in your background, you have to have a credit background check, you have to have a criminal background check, an application, like there's a whole process. If you don't have anybody that qualifies, that is within like your family or someone that your family trusts, you may be in a situation where they appoint what's called a public guardian, and that's going to cost you because not only are you paying to establish the guardianship, you're also going to be paying the person that is serving in that role. And either way, you're going to be paying. So it's just going to be dollars and dollars and dollars being spent, all because you don't have things in place, or you have things in place, but they weren't done properly.
So a public guardian, this is not a benevolent activity. I
So
thought,
if you, sorry, let me rephrase one thing. A public guardian is the one that usually if they're what is it called? Indigent. So that's a public guardian. I was speaking of professional guardian. So you have a professional guardian who's paid to do that as a job. You have the public guardian. If you don't have any money and you have to go into a guardianship, you know, the court will typically either appoint or, you know, they will connect you with a public guardian, like Dade County has one, Broward has one, etc.
got it. So there's a question in the chat actually from my husband. I'm going to rephrase it for him because he and I had the same conversation, and I was super excited to be talking to you because I wanted to ask you to clarify it for us. So his question is that if someone has an estate, and I think what he means is a will, because that's that, and this helps transition into the next thing that I really want to ask you to explain for us. If someone has a will, do the beneficiaries still have to go through the probate process? Which I'd like to use this to transition into, tell us a little bit about what a trust is and how that, who should choose the trust? How does it help? When, under what circumstances is that a great option? Is that a good option?
Okay, so I'll answer the question first about if they have a will, do the beneficiaries have to go to probate? So there's reasons why people go through probate. If you have a will and the will says, when I pass away, I want my house to go to my 2 children, you're going to have to go through the court process. Remember, the will is only a document that gives instructions. That's all it does. It does not do any transfers of property unless it's like personal property, right? Like if I have artwork, jewelry, household items, furniture, all of the little things that, you know, are part of someone's life that probably don't have much of a value or a high value in terms of monetary. If you have a vehicle there, you know, you can, I know that with the Department of Motor Vehicles, they have their own process for you to transfer a vehicle. So let's say your husband or your wife passes away, you can take the will, the death certificate, they have their own form that you have to fill in. And I believe they have some other thing that you have to complete as well. But I've had clients where all they do is take the will to the DMV and they can do the transfer to the surviving spouse. I've also had instances where children do the same thing. As long as their name is listed in the will, it's on the death, and I think the death certificate has to list their name as well. You know, they complete a form with the DMV, they have their own process. Things like boats and other things like that, they would be transferred, you know, by, you know, the person who's handling the final affairs or the personal representative. But if you have assets that require some kind of a transfer document, like real estate, got to go through the courts. If you have bank accounts and unfortunately your family member did not have a beneficiary listed and there was no joint owner on the account, then you're going to have to go through the courts to get a court order to take to the bank to say, here, you know, the money is supposed to go to me or to us. You know, so there's some steps that have to be taken if you have a will and you have property that has to be transferred in some way, because you're going to need the authority to get access to that property.
So property that is deeded in a major way. I mean, because I know boats and cars also have titles, but property that's deeded needs to be transferred officially, and that has to go through the court, even if we had a will executed properly and in place.
Correct, because again, the will doesn't do anything but say to the court, this person passed away, this is what they had, and this is who they wanted to go to. And now the court has to provide an order. Same thing with, you know, investment accounts, bank accounts, anything else that you own that has your name on it only. You have to have some document to take to the bank, to the investment company, to the insurance company to say, you are now authorized to receive those monies, or here are the people that are authorized to receive the monies.
So I spend most of my time working as a realtor, and I cannot tell you how many times we have come across situations where an elderly person, this happens a lot with reverse mortgages, because the reverse mortgage, the explanation to everyone, which I'm not anti-reverse mortgage by any stretch, that's a different conversation. But when it's explained to families, it is that once the elderly person passes away, the heirs only have to satisfy the debt up to the value of the house, right? But what we don't realize is that if the parent's name was the only one on the property, when they pass away,
Right,
it's either you go through probate
right,
or the bank literally takes the property, because unfortunately a lot of times those properties are somewhat upside down. I've had situations where they would like to keep it in the family. Well, we'll pay it off and we would like to keep it in the family,
right,
but in order to get the title from Amaral to Sandy, it has to still go through the courts. And more than once, I have seen more than one property where the family is like, it's not worth it to go figure this out. They only have this one property. um, we'll just let the courts figure it out when they figure it out. So yeah, so I really, it's really important, and it happens to us in our communities every single day.
right.
Um, they know those were my kids. My kid, it'll go to my kids. Some steps have to, some things have to happen in order for it to go to your kids.
Yeah.
Here was my follow-up question. Tell us about trust. I'm very interested in what is a trust, who is it for, who does it benefit?
So the beauty with trust is, to me, they are the most misunderstood types of tools. And there's so much misinformation that I hear people, sharing. It's just amazing. A trust is basically a document that not only gives instructions, but it allows you to have title of whatever it is that you own in the trust, because you can fund the trust with things like life insurance, your real estate, bank accounts, other financial accounts. So you can use these things to fund the trust, because what happens is you're going to retitle what you own in the name of the trust. So now the trust becomes the holder of whatever that is. And the trust can also be a beneficiary, for example, of like your life insurance and investments and things like that. The difficult part with trust is to understand that a trust is not for everyone. It is a contract, and it is a contract that you make while you are living. And typically, most people will have what's called a revocable living trust or a living trust. And it's a contract that you make while you're living with an individual that you are going to establish as your trustee. Typically, when you're living, you create it, so you're going to be the initial trustee. And you're basically saying, when I pass away, here's what I want. And you could set it up in a way where it's like, if I have minor children, they're not going to receive monies until they turn 21. And then every year for 5 years, they're going to receive an allowance. And then if they finish college, they'll get a lump sum. If they go to business school, they'll get a lump sum. So you can dictate from the grave how you want your estate to be distributed over time. That's the value of a trust. It's something that pretty much anyone can use if their intention is to control their monies or their property even beyond the grave, right? So it's something that many times I see, married couples use, because if you have minor children, you don't want to put your minor children on your life insurance policies as beneficiaries. You want to make sure that you have something that is going to control those monies, because what happens if you pass away while you're young and your kids are young? You want to be able to have things in place where you can have a trustee that's going to handle the children's expenses, that's going to make sure that the children, accomplish certain things before any monies can be spent on them. That you can make sure that your children's and any processes that you want the children to go to before they receive any monies from the trust, that they're able to follow that through the trustee. So you can manage from year to year to year for generations, which is why many of these foundational families that you see in the United States and other countries, who keep money and wealth in their family from year to year to year to year, it's because they have things like trust in place. And they're able to kind of piecemeal money from generation to generation, right? So what makes a trust different is that it can survive your death. So while you're living, you can operate under your trust. You can create the trust, you can fund it with what you want, you can title, different things like the business, and you can have different things titled in the name of the trust. So your trust is going to serve as the holder per se. So just think of, again, a container, and whatever I own, the trust is in control of it through the trustee. If I need to do a trust, it's because I have a desire to handle my monies and my property beyond my death, and sometimes even beyond the death of my children and their children, because I want to kind of spread things out over generations. So many times the reason that people get a trust done is because they're desiring to kind of support some generational wealth. They want to build up money in their family. They want to leave a legacy. They want to have some money set aside so that their children don't have to go through the experiences that they went through. You don't have to have a trust, right? It depends on your circumstances. So when people come to me and say, hey, I need to get a trust, they told me I should put everything in a trust and I need to get a trust. No, that's not what you need to do. You need to speak with someone who can talk to you about your circumstances. Because if you come to me and you say, I have adult children, I want them to get what they're getting the moment that I pass away, a trust has no value there. However, if you're saying to me you have concerns while you're living, you want to make sure you have some protections in place and that you're able to control things while you're living, even if you become incapacitated, that you'll have a trustee in place that can handle all of your affairs, especially when it comes to money and any kind of assets that the trust is going to have control over. So if you have some real estate and you've transferred the interest of the real estate to the trust, then the trust is going to control that real estate. So if something happens to you and you become ill, your trustee can step in. Now, if you're the first trustee, of course, you're going to have, a successor trustee, somebody that's going to step in the moment that you become unable to do so any longer. And then you'll also have some provisions in your trust that says, well, what happens if all of my trustees pass away? How does the next trustee get appointed or nominated? So a trust is a great tool. It's a great way for you to kind of set aside a plan for your family. It's a great way for you to be able to build up things like life insurance policies over time and not have to feel concerned about having your minor children listed on those policies. Because let's say your life insurance policy is set to pay out your child $50,000. That's way above the threshold of what's allowable for a minor child to receive without having a guardianship of the minor. So if you're leaving things like life insurance in place with your children's names, you are creating another court process. So the moment something happens to you, guess what happens? If you die and that child is under age 18, your family is going to have to spend money to open a guardianship, which is going to be managed by the court until that child turns 18. And that's something that you really don't want. So a trust can step in really well there. The last place that I really like to see trust is special needs. If you have children with autism and other special needs or conditions, it is a great tool because you can create what's called a supplemental needs trust or a special needs trust within your revocable living trust that allows you to protect any monies that you want to set aside for your children or any property that you want to set aside for your special needs children without them losing the benefits of any government assistance that may be available to them. So a supplemental needs trust, or what they call a special needs trust, within your revocable living trust or as a separate standing document, will allow you to give your special needs child some long-term care needs, supplemental treatments, medical care, respite care, all of those extra things that your child is going to need. So a trust is a great, great tool. However, the big question with trust is, what is your intention and how do you want your affairs to be distributed if you become unable to handle your affairs and when you pass away?
So there are a lot of great tools, but talk to a professional because it depends. Yes. Not every job calls for a hammer. Sometimes a mallet is just fine. Right. So I wanted to ask health proxies. So we talked a lot about if a person passes away and what that looks like, what preparations that person should make. I wanted to circle back around to in the event that, and we've touched on it just a little bit, but I want to hit it specifically, in the event that someone becomes incapacitated and they're unable, whether a lot of us, we find ourselves, Sandra actually shared this earlier, stuck in between two generations. We have our children on one side below, and we have our parents above, and we are somewhere in the middle, navigating the needs of both of them at this juncture in life. So, Mike, I'd love to hear a little bit about what is a health proxy and uh, who should have a health proxy, or who most often benefits from having a health proxy.
So in essence, when it comes to healthcare decision making, you know that we have HIPAA laws in place that prevent your healthcare information from being shared without you having some paperwork in place. When you go to the doctor, a lot of times your doctors will have you fill in some kind of a proxy type form. When you go to the hospital, they'll typically have you fill out a proxy. However, understand that those documents are specific to the facility that you're going to, right? So you need to have your own healthcare documents in place. So the documents that we typically use here in Florida, you have your living will, which is a document that identifies your end of life decisions. So if you are terminally ill, like an end stage condition, if you are in a vegetative state, if you have a condition where the only thing that's going to keep you alive is some kind of artificial means, like a ventilator or something like that, there is a document called a living will that allows you to say, I don't want to be kept artificially alive if the doctor has determined that there is no possibility of me surviving without the assistance of this machine. So that's one healthcare decision that you can make in writing that is not just something you'll do at your doctor's office, but a document you can create yourself, right? You go to an attorney or to another professional to create that document. The healthcare designations that include the HIPAA language that allows someone to access your healthcare information usually falls under the category of like a designation of healthcare surrogate, or sometimes people will call it a medical power of attorney. And basically all it is you designating a person or persons who will make healthcare decisions on your behalf if you can't make those decisions for yourself. And it will include being able to access your medical information. It'll include being able to communicate with your doctors about your medical information. And it's just basically an authority, just like a power of attorney allows someone to access financial information and financial accounts and things like that. A medical power of attorney allows someone to make decisions for you about all of your medical care and all of your medical
Let me ask, would it not default automatically to, let's say, to someone with a spouse, to either my spouse, or if I am an unmarried adult, would it not default automatically to one of my parents? Can I assume that?
So here's the tricky part. When you go into the hospital, many times the hospital is going to seek out and speak to family members about decisions. However, let's say you have your spouse come in. Your spouse wants to speak to the doctor and says, my wife doesn't want to be resuscitated. If she flatlines, she doesn't want to be resuscitated. Your parent comes in and says, no, my daughter would never want that. She absolutely would want to be resuscitated. Who wins that conversation? So the doctor at the hospital is going to need to know who has the true authority to make decisions. Now, in that instance, a lot of times I've seen them defer to like the spouse, right? But if that person has their documents in place, there's no need for a battle. The documents will speak for themselves, right? So it's an important thing, because if you don't make the decision advance directive wise, right? If you don't make a decision in advance, someone else is going to be burdened with that decision. And it may not be the person that you want to make the decision. I remember years and years ago where the woman that had the feeding tube, there was a battle between the husband and the family, and it was just like a whole thing. But again, whose voice was being heard? The husband or the family? The voice that was missing was the voice of the person who was going through the situation. So the importance of advance directives, medical power of attorney, any document that has to do with your healthcare decisions, is you being able to speak through your documents when you're unable to speak for yourself. That's at its core. So having those documents in place saves your family from having to make these harsh decisions on your behalf. And it also saves a lot of conflict, because as we all know, we have a lot of competing interests in our families, right? If I have a spouse, they're probably going to feel a certain way about something. And if I don't have documents in place, they're going to have a view according to their thought process and our relationship. Whereas my parents or other family, my siblings and things like, they're going to have their view. Imagine having to go through a court process fighting with your family over what your, maybe sisters and brothers fighting with parents saying, well, my sister would have never wanted that. And the parents like, well, my daughter doesn't need that because we're, whatever religion, right? So it's just making decisions for yourself through your documents. And that's just, to me, looking at estate planning as a whole, will, power of attorney, trust, all these documents, it's us making a decision now about what's going to happen tomorrow, next year, 10 years from now. That's what it comes down to. Making decisions now versus paying for our lack of decision making later.
So Rudy in the comments wanted to clarify his question because his wife got it wrong. So
Okay.
he said, his wife being myself, he said that what he really wanted to know is what is needed to avoid probate. If you are estate planning and you would like to avoid probate, what would you need to put in place in order to avoid the probate process?
That's a great question. So probate avoidance is a tricky question, right? Because here's what happens. What you own when you pass away has different avenues. And if you don't have any documents in place, you're going through probate. If you own something that needs some kind of court paperwork, right? If you do have a will, there's a possibility that you may not have to go through probate. But this is where the planning comes in. This is why it's important to have a professional do your planning, because if you don't strategize about all of the different things that you own and the things that you want to happen, there's a possibility something will be left out and you still end up in probate even after taking precautions. Because here's what happens. I will have a situation where I have a will and somebody pops up and says, my mom never created a will. She was pressured by the other sibling to go and get this document done, and it was not her intention. So guess where we end up? Probate. Now this is with a will. My mom never had a will. She voided out her will. She tore it up, blah, blah, blah. Well, guess what happens? We have a conflict now. Where do we end up? Probate. So it's looking at what you own and figuring out what's the best way to prevent issues. Beneficiary designations, to me, are a great strategy to make sure that you don't have anything in your estate that is going to require a probate process. However, if you don't make sure that you have contingent beneficiaries, the moment that your beneficiary dies and you're still living, if you pass away now, you have no beneficiary on your account. And I can't count how many times I've had a 401k, bank account, another finance, like an investment account where they had a beneficiary, but by the time the person died, when we went to find out from the different companies, hey, beneficiary, nope, the beneficiary died. And there was no contingent beneficiary to step in to receive. So now you have no beneficiary. You have an asset in the name of the deceased person only. And where do we go? Probate. So in order to avoid probate, which I don't like the word avoid probate, because honestly, I don't really feel like there's a lot of ways to avoid probate because of the fact that I see so many people in court that have no business being in court because there was a will, everything was in place, like all the stuff was done. But when you have things like will contests, when you have issues with the family and there's family conflict, you can't avoid probate in those instances. What you can do, however, is take the time now while you are living, breathing, and able to look at everything that you own. And are you able to, and ask yourself, am I able to point to what happens to each of my assets if I pass away today? So if I have a bank account, do I have a beneficiary? Do I have an extra beneficiary just in case the one that I want passes away? If I have real estate, do I have a deed that is going to allow me to transfer that property upon my death? They call it an enhanced life estate deed or a ladybird deed. And it's basically I am still in possession of my property. I have maintained my right to sell my property and do whatever I want to my property during my lifetime. But when I pass away, I'm making the decision now that when I pass, my property is going to go to this person or this person or this person or all of these people, right? I'm making a decision now. If I have financial accounts, have I spoken with my financial advisor to make sure that I not only have beneficiary designations, but I have contingent beneficiaries? Have I checked my 401k, my IRA, whatever, 403b, whatever the investments are that I have? Have I checked them to make sure that I have beneficiary designations and contingent beneficiaries? Have I verified the other things that I own, right? I had, when I was in law school, when I did my clinicals in law school, my very first client in the estate planning clinic said to me, I'm giving everything away right now. I just want to get my will done just in case, my power of attorney, just in case, my medical documents, just in case. But I'm giving everybody everything now because I don't want anybody fighting over anything. And you know what? When I thought about it, I was like, that's a really great idea, because how many times do we sit around in our houses and there's things that we never touch for years and years and years? Why not start to give those things away? So those are probate avoidance, right? If it's not in the estate, it's already gone. That's one. Number two, if you ensure that you have backups for your backups, you have a position. And then the last one is having a trust. So if you really want to have some options, a trust is helpful, but I can't guarantee you that somebody is not going to sue your trust or, try to fight you over the terms of the trust. I can't guarantee that. But the trust does not go through the probate process. There's a whole nother process for trust. If there's an issue with the trust, there's trust litigation. But I don't see as many issues there as I see in the probate process. Okay. Generally speaking, with your everyday family.
I want to pull you in one more direction.
Yes.
I want to pull you in one more direction. We're just a little over an hour right now. One of the things that I'm super happy and excited to see happening more and more is that many of us are venturing out into the world of entrepreneurship. Many of us are starting businesses, especially over the pandemic. There was definitely a wave of people that are using their natural talents and the skills that they've acquired and are starting businesses. And many of those businesses are either single, let's say single person. Let's not complicate things with partners and partnerships and what in those things. As business owners, single member LLCs, or even single shareholder corporations, we're starting off our businesses, and hopefully we're going to build them to a place of something to be able to pass on.
Right.
When someone passes away as a single owner to a business, what happens? And in your professional opinion, what should we be doing on the front end so that that transition goes as smooth as possible?
So one of the things that I've noticed a lot with, this emergence of so many business owners, these entrepreneurs, most people start the LLC or whatever the other entity is, and that's pretty much it. There's no business plan. There's no language in their business documents that says, well, if I pass away, this is what happens. If the business, or
no operating agreement. No,
there's nothing. There's nothing. And we're all guilty of it, because when we start out in business, the only objective is we're trying to make some money, right? The problem is, if you don't provide some kind of language in your business documents, your operating agreement, your incorporation documents, if you don't provide language that addresses what happens, you potentially risk having to have a probate process dictate what's going on with business interests, right? Now, if you have a business set up where you have, different people, obviously there's some other people that would be at play, and then there's going to be a question of what your interest is and the other. But when you're an individual business owner, this is basically an asset of your estate. And if there's nobody else, we have to figure out in the probate court process, does the business have any monies? Do we have to, have any orders prepared? to give authority to maybe a business bank account or anything like that. So sometimes I see business entities going through like probate process issues, and it's mostly because maybe they need to get a court order to be able to either continue the business operation, or to be able to shut down the business operation, or to be able to obtain information like from a bank or other institution. So I think what people need to understand is with businesses, there is planning for businesses. It's called business succession planning. And it's basically you planning for, well, what happens if you get sick? What happens if you pass away? What happens if there's a natural disaster and you lose all of your inventory? What happens if there's somebody hacks into your system? We have to have a plan of action for what we're going to do, and we also have to have things like insurance to protect our business interests. Because if you have insurance, now you have something that's going to say, well, if this person passes away, I have insurance coverage to address, any end all situations, to cover any outstanding expenses, and to basically wrap up the business affairs if that's the intention. But much like you do estate planning for yourself and your property and your family, you're going to do the same thing for your business. It's organizing your information, identifying what you want to happen, and making sure you have documents in place. Sometimes I see things like buy-sell agreements. Sometimes there's other paperwork that needs to be filed with the corporate documents or with LLC documents. So it's just a matter of, sitting down with a business professional who handles business entities. There are attorneys that, do business entities and things like that. But sitting down with someone to make sure that your documents that support your business identify what happens. Same as us having a will or having a power of attorney or a healthcare designation. This is just specific to the business.
Because your business is its own entity. I always like to describe to people that your business is, although it may bear your name,
right,
is like having a child. Technically, it's its own thing. Over here, you may have care, custody, and control of it for the time, but it belongs to itself, and we kind of need to make plans for it in that vein. So to wrap up, for average person, let's build a person. You are a working professional, you have a spouse, you have elderly parents. Where do we start? What some basics from your perspective? Where do we start? Which parts of these are most important? Which might be kind of hard to weigh because it all sounds very important.
Right.
When we're faced with it, but where should a novice begin?
So my favorite part of where to begin has to do with educating yourself on what's out there. There are a lot of resources where you can find information. I know that the Florida Bar has something called consumer information pamphlets, and it's basically a section of the Florida Bar website where they have consumer information, so different legal topics. And I know that they have a whole section on estate planning, probate, and guardianship. Okay, I'm going to try to put it in the comments when I'm done. So that's a first place. Second is understanding that there's two categories of documents that you should be thinking about. One is your living documents and one is your after death documents. And then you can also think about something like a trust, which is kind of living and after death. So if you at least start with while you're living, you need to have certain things in place. You're going to get a durable power of attorney to handle your financial decisions. You're going to get a living will and healthcare designation to handle your medical decisions. And then once you've at least secured those things, you can now start looking at, okay, I need to get a will in place. Then you could look in, well, if I own real estate, I probably need to get some kind of deed done. That way I'm covered. If I pass away, my property is taken care of. I can do my beneficiary designations on my account, and I at least have a foundation. So durable power of attorney, living will and healthcare designation, and a last will and testament. That's your foundation. Once you have that set, the other things that you can do, and I almost say that the beneficiary designation should come first before you really start worrying about getting all the documents done. Check all of your financial institutions. If you're over there investing in some stocks on Robinhood or whatever these websites are, find out if they have a way for you to put a beneficiary on your account. If you have life insurance, double check that you have beneficiaries and contingent beneficiaries. Go to your bank. Let the banker know, hey, I want to put a beneficiary on my account. So if something happens to me, somebody, don't add a joint owner. I have warnings about that because I see a lot of people, hey, just put another name on the account. Well, please understand, if you have a joint owner, joint owner number one can clean out the account and joint owner number two can't really say much about it. Joint owner number one may have creditors after them seeking garnishment and wipe out the account. Joint owner number two is like, what in the world? That was my money. So you want to be careful about, just being a joint owner on accounts, and understand that you really just need to provide yourself with beneficiary designations on all financial accounts. And I mean every single one that you can think of. If it's an account, ask them if you can put a beneficiary on it and make sure that you have double. So if you have a primary person as your beneficiary, you also want to have somebody as a contingent beneficiary to address those needs. The second thing is, to understand that your decision making has to do with what your intentions are. What is it that you want to happen if something happens to you today? What do you want to happen if you fall into the hospital, coma, whatever it is? And what happens after you pass away? How do you want that process to look? If you can kind of visualize it, iron that out, write that information out. Act like you're journaling and write down these pieces of information. Last but not least, in my big picture of things that we can do, it's very important that people are able to figure out what you own and what you have an interest in. It would be very wise for you to organize your affairs into folders. Let me get my financial information together. Let me get my medical information together. And let me get all of my activities of daily living together. That basically means this. I should have all of my financial statements. So someone who has to handle some things for me has access to know these are the 10 accounts that she has. These are the passwords. These are the names of the companies. These are the phone numbers. Medical information. You should have a copy of your medical records somewhere that's accessible. You should have information on who your doctors are, who your medical providers are, your hospital, their phone numbers, if you have accounts or medical insurance or whatever. All of that should be organized in a place that you feel is safe. And then activities of daily living. All of us have things that we do from the time that we wake up to the time that we lay our head to rest for the day. How is someone supposed to know what it is that you have to do each day if there's not really a guide? So it's important for you to start to kind of put together information on what are the things that you have to do every day, right? If you have kids that you're responsible for, if something happens to you right now, how are they supposed to know that they got to go get the kids from the school, right? How are they supposed to know that you pick up your mom every Wednesday to take her to an appointment? How are they supposed to know that the lawn guy comes on Saturday morning to pick up a check, right? You want to start documenting your activities of daily living so that if someone has to step in as your representative on your behalf, that they have some materials to work with. And the reason I say it is because I can't count how many times someone passes away or someone gets ill and they're in the hospital. And literally I, as the attorney, have had to go to a home to look for information. So it's estate planning is not just, hey, I got to go get a will online. I'm going to fill in the blanks, put it aside. It's there, done. Estate planning is a comprehensive process. It involves you asking tough questions and ironing out those tough answers. It involves you putting information in place where it's secure and someone is able to access it. And it involves also thinking about what are your ultimate intentions to make sure that you have the necessary things in place so that those intentions are actually put into reality.
Sandy, this has been truly, truly spectacular. There are things in our everyday lives that we don't slow down and stop to think about.
Right.
The two things, death and taxes, are guaranteed. These are things that if you are going through this life and living this life, that we all shall pass this way.
Right.
And all too often we put these things off because we're busy living our life. So those that will come across this video, those that were able to join us this afternoon, this evening, absolutely, this is information that you may not have gone out seeking if you had to do all of this research on your own, but Sandy brought it right to you right here on Facebook. And I hope that you'll go back, listen to this video again, and take notes where needed. And if you have any specific needs or specific questions, where can we direct people to get in touch with you, Sandy?
So you can basically go to my firm's website. It's www.thespectrumlawfirm.com. I'm going to put it in the comments as well. So again, it's www.thespectrumlawfirm.com. And you can also find us on Facebook and Instagram. Just look up Spectrum Law and you'll find our information.
So we have no excuse for not getting the information that we need. We have awesome professionals in our community that are jazzed and excited to actually share with us. And once they have given us a taste of their professionalism and what they can share with us, I really, really hope that we as a community, that we will go out and we will support those that are bringing their expertise to us. So with that, thank you so much, Sandy. Really, really appreciate every time I get an estate planning question. I really do send them in her direction, and have not been disappointed, not once. So I am definitely endorsing and encouraging you to give Spectrum a call and let Sandy guide you down this very complicated route. Sandy, don't go away yet. I'm going to go ahead and shove off. But thank you so much, everyone. Please share this video, share your questions in the comments, even post, and we'll be sure to come back in our comments and actually share some answers for you if there are specifics that you may have. And with that, thank you for coming, everyone.